Good afternoon, good morning, or good night, depending on where you are watching this from. My name is Sam, and along with my teammates, Saloni and Alex, we are representing the Entrepreneurship and Community Business Clinic, and we will be talking to you today about an extremely exciting topic, legal liability waivers. If you run a small business where customers or clients participate in activities, visit your office, or use your services, there is always a risk that somebody could suffer or cause harm at your place of business, and there is unfortunately the risk that somebody may try to hold you liable for that harm. A waiver is a legally binding document that, if done correctly, can protect your business from a customer or a third party pursuing a civil damages claim against you. And if your business involves any degree of risk, a waiver should always be a part of your legal risk mitigation strategy. Before we start our presentation today, we just want a brief legal disclaimer. This is general advice. This is not legal advice, and we are not advising you on the specifics of your legal liability waiver. As always, if you are drafting a legal liability waiver for your small business, please consult an attorney. Second, a mention about scope. Legal liability waivers and the requirements of each waiver depend on the state that they are created in. Please never rely solely on a document or a draft that you get from any website. It has to be specifically tailored toward the state that you are in.
Today we are going to cover 5 key areas. First, we're going to discuss what a waiver is. Second, we will discuss the benefits of having a well-drafted waiver. Third, we will walk through the essential components that every liability waiver should contain. Fourth, we will explore common legal pitfalls that can render a waiver unenforceable. And finally, we will discuss best practices for implementation and record keeping. So, as we discussed, liability waivers help protect you from risk arising from people getting injured or damages that may occur on your premises or when an individual engages in an activity. They're primarily used before customers engage in a certain activity, especially those that can be considered dangerous. This includes participation in sports, use of a fitness center, or attendance at an entertainment event. You've probably encountered and even signed liability waivers before. They're common at gyms, sporting events, adventure parks, and even everyday services like moving companies or contractors. They serve as a form of risk management. A well-drafted liability waiver releases a party from liability that may occur. The customer signs the waiver to absolve the owner or operator of liability claims, which can include claims arising from the owner or operator's own negligence. Many activities carry inherent risks. A skydiving company, for example, cannot eliminate all of the risks from jumping out of an airplane. Waivers provide an avenue for businesses to exist without exposing them to risk that may make operating the business more trouble than it's worth. We'll next discuss the potential benefits that having customers sign liability waivers may have for your business.
Thank you, Saloni. Next, we will turn to the benefits of having a well-constructed, broad liability waiver. The single most beneficial reason to use a liability waiver is that it reduces the risk of litigation, and it can help protect your business from any sort of outside and civil damages claims. When a customer signs a waiver, they agree to give up the right to file a lawsuit against you for any sort of risks inherent to your business. This level of protection can shield your profits, the business's reputation, and help you avoid any unnecessary and expensive legal claims. Benefit 1. The first benefit to having a strong legal liability waiver is what I mentioned before. It reduces the likelihood of litigation. Having customers sign waivers and other releases can save your company from potentially harmful negligence lawsuits. I want to be clear here that liability waivers do not make a business immune from lawsuits, but it does provide a great defense if somebody brings a lawsuit against you. This is because many potential claimants will reconsider pursuing action when they have signed a clear release of liability. The second benefit of having a strong legal liability waiver is that it promotes informed consent and customer awareness. A waiver creates a document for the record of what exactly was communicated to the client, the risks that they agreed to, and whether or not they acknowledged these risks. In the event of a dispute, having this type of document means your business can reconstruct with hard evidence what happened rather than relying on a memory in the event of a dispute. This is especially important because in California, for any sort of personal injury claim, that claim can be brought up to 2 years after the event happened. So by having this type of hard evidence, you don't have to rely on the memory of you or your employees. You can reconstruct exactly what happened. The third benefit is having and complying with any sort of potential insurance obligations. Many professional liability insurers specifically require documentation practices in their terms of service. Having a clear waiver program will protect you from a lot of liability and that can affect your premium costs and allow you to remain in compliance with any sort of insurance obligations that you may have. The fourth benefit of a strong liability waiver is that it can build customer trust and rapport. A waiver is an opportunity to inform your customer of the inherent risks of your business, and it will allow them to choose whether or not they agree to these risks. This transparency can actually improve customer trust and customer relationships because it demonstrates that you take safety seriously. Next, we are going to turn to the essential components of a strong liability waiver. Now we are going to turn to the essential components of a strong and successful liability waiver. To be valid and enforceable, a waiver must contain certain key language. Failure to include all of these components could result in an unenforceable waiver. The first essential component of a strong liability waiver is a clear identification of the parties. The waiver must contain the name, the full legal name of your client, and the name of your business entity. If you operate under a trade name or a DBA, you must also include these names in your waiver as well. Courts have found that ambiguity about which entity is covered can be a basis for challenging the enforceability of the waiver. This is because in California, this ambiguity will be resolved against your business as you are the drafter of the document. The second essential component of a strong liability waiver is a specific description of the services that you will give the client. An effective waiver must have a clear depiction of the services offered. You must describe the exact service, the treatment, or the activity being covered. California courts are very skeptical of broad language that attempts to cover the activity. For example, unpreferred broad language would be something like any and all services to be provided by the business. That is too broad and does not inform the client of the specific risks that they will be agreeing to. The third essential component of a strong liability waiver is an explicit description of foreseeable risks. List the known and foreseeable risks of the specific service in the language of your liability waiver in a way that a person without a legal degree can understand. Include the common risks of the activity and the rare but serious ones to give yourself a broad protection against any and all risk. California courts looked at this section closely because a waiver that describes the risks vaguely or in a type of strong legal language or legal jargon, this will give the court reason to say that the client was not fully informed of the risks that they were agreeing to. The fourth essential part of a successful liability waiver is an acknowledgement of understanding by the client. Waivers are all about shifting risk, but the client needs to know what risks they are shifting. Thus, it is important to include an explicit statement that specifies that the client confirms that they have read all of the terms, all of the conditions, and they have agreed to all of them. This is the best defense against the most common challenge to a legal liability waiver, which is the client's later claim that they didn't understand what they were signing. A strong acknowledgement clause will reinforce the idea that a client who signs the contract has read it and has understood it. The fifth essential component of a strong liability waiver is a release clause specifically referencing negligence language. This is one of the most critical requirements and is thought of as the heart of the waiver. This section states that your company does not carry the liability burden arising from any harmful events that are events specified in the sections that we already covered. This section should explicitly reference negligence and make clear that the participants in the activity are waiving their right to bring a claim regarding negligence. The general rule in California is that courts will not read in a release of negligence into vague exculpatory language, which means that if a waiver does not include the negligence language, it will not be a part of the waiver. The sixth essential component to a strong and enforceable liability waiver is to include an indemnification clause. This section of the waiver is an acknowledgement by the client that they agree to pay you legal costs and attorney's fees if their actions result in someone else filing a lawsuit against you. For example, if the client is reckless in your place of business and hurts another client, and that second client brings a claim against you, this section in the liability waiver will allow you to go after the first client for any legal fees and attorney's costs that you incur in that lawsuit. The seventh essential component of a strong and enforceable liability waiver is a voluntary agreement statement. The waiver must clearly state that the client is signing freely without coercion and that they understand that they have the right to decline service. A document signed under duress or pressure is unenforceable in California and could render your liability waiver unenforceable. California courts take the circumstances of signing extremely seriously. The process must support the language in the document. Alex will cover this in a little bit in his section. The eighth essential component of a strong and enforceable liability waiver talks a little bit more about the process of signing. The language contained in your waiver must be conspicuous. California courts pay close attention to how a waiver is presented on the page. The release clause, releasing you of any sort of liability to any negligence, must be clear, which means legible and conspicuous. The best practice, which we will talk about later in this presentation, is to make the font size no smaller than 12 font, to have clear formatting, use bold section heading, and visual separation to ensure the client knows exactly what they are signing. The last and ninth essential component of a successful and strong liability waiver is the timing of the signature. Again, this goes directly to the process of signing the document. The waiver must be signed and dated before the service begins, full stop. Usually, California courts say that a post-activity signing of the waiver renders the waiver unenforceable. Next, Alex will turn to the common pitfalls in drafting a liability waiver.
We talked about the benefits of having a waiver, but if a waiver ends up in front of a judge, it's going to be put under a microscope. A poorly written waiver is oftentimes as bad as having no waiver at all. Let's talk about some of the most common pitfalls small business owners make when creating their waivers and how you can avoid them. The first is the catch-all trap. A lot of business owners think that they can just include a sentence in their waiver stating that the customer agrees not to sue them at any time for any reason whatsoever. Sound foolproof? Unfortunately, courts hate this. If your waiver is too broad, a judge might throw it out entirely. Instead of being vague, your waiver needs to be clear about the actual risks involved in running your business. For example, if you run a gym, your waiver should explicitly list any potential dangers such as weightlifting injuries, equipment malfunctions, and even more serious risks such as cardiovascular events. Another pitfall, tiny fine print. We've all scrolled past a massive wall of tiny text and immediately clicked I agree when signing up for a new service. But when it comes to a liability waiver, burying the release in the middle of a 5-page document in size 8 font is a big mistake. The law usually requires the waiver to be obvious. Put your waiver on its own page or in a separate bolded box. Use clear headings. Your customers should never be able to argue that they didn't know they were signing a waiver. Pitfall number 3 is forgetting the magic word, negligence. This is a really common mistake. Most business owners write a waiver to protect themselves if someone gets hurt by accident. For example, if an employee accidentally leaves a mop bucket out on the floor and a customer trips. In legal terms, that kind of accident is called ordinary negligence. In many states, if your waiver doesn't explicitly use the word negligence, it won't protect you from it. Don't just say any and all injuries. Make sure your document specifically states that the customer is waiving any potential claims for negligence. And finally, another common mistake is letting children sign waivers for themselves. If your business serves minors, such as a trampoline park or youth sports camp, listen closely. Under the law, a minor generally cannot be bound by a contract. If a 16-year-old signs your waiver and gets hurt, that piece of paper is likely legally useless. Always have a parent or legal guardian sign on behalf of the minor. However, a parent's signature is not a complete shield. In many jurisdictions, such as California, courts have held that a parent cannot waive a child's right to sue for personal injury. This means that the minor may bring their own action upon reaching the age of majority. In California, the age of majority is 18. Additionally, A waiver signed on a child's behalf generally does not prevent parents from pursuing their own independent legal claims, such as a claim for negligent infliction of emotional distress if they witnessed the accident, or a claim for medical expenses incurred on the child's behalf.
We're now going to discuss the relationship between waivers and the courts. As we mentioned earlier, courts may refuse to enforce your liability waiver. Because a waiver helps to avoid liability, courts generally disfavor it and strictly construe it against the party seeking to rely on it. This means that you have to be careful when drafting your waiver. As a reminder, waivers serve to reduce risks, not provide guarantees against risk. Even a well-drafted waiver may fail in front of the court. So the following considerations are important to keep in mind while drafting. Courts in different states have different standards. The majority view, which includes California, holds that agreements that release a party from liability for its own ordinary negligence are generally enforceable, if they don't violate a statute or a public policy concern. Courts have allowed waivers across a range of activities from parachute jumping to vehicle rentals. However, some states have stricter regulations. In New York, for example, courts do not enforce waivers for establishments such as pools or gyms that exempt owners or operators from liability to paying customers for the owner or operator's negligence. It's important to keep in mind that laws and courts in your state might have specific requirements on how you can draft and use your waivers. Although protection from your own ordinary negligence is generally enforceable, courts do not enforce liability waivers for gross negligence or willful misconduct. Ordinary negligence, as we touched on earlier, is when you fail to exercise the degree of care that a reasonably prudent person would use under similar circumstances. Gross negligence is a more serious form of negligence, and it occurs when there is an extreme departure from the ordinary standard of care or reckless conduct. Willful misconduct is the most extreme, and as it sounds, it occurs when there is an intent to cause harm. However, willful misconduct also covers situations where there is a conscious indifference to the consequences of your acts or omissions. If your activity falls under gross negligence or willful misconduct, the court probably won't enforce your waiver. Another reason courts may not enforce your waiver is because it violates public policy or statute. A public policy issue may come into play if a waiver concerns a subject that is of great importance to the public, one of the parties has a significant advantage in bargaining for the waiver, or if the waiver puts the party signing under your care and control as the party seeking release from liability. Courts consider a variety of factors when deciding on voiding a waiver, including whether the business is suitable for public regulation, the services are of great importance to the public, how openly the party holds its services out to the public, the bargaining power of the parties, and the impact of the waiver on the signing party. For example, take it or leave it agreements are generally disliked by the courts because they give the drafting party significant power over the person signing the waiver. Statutory restrictions depend on states. The recreational facility restriction in New York is a good example of how statutes can impact how you draft your waiver. A release may also be invalidated if the court believes it was obtained by fraud, deception, misrepresentation, duress, or undue influence, if there is an issue with the scope of the waiver, which includes if the issue is not covered by the waiver, or if the waiver itself is too broad, judicial hostility depending on the jurisdiction, and a change in circumstances. One last thing to consider, special relationships between you and the party signing the waiver may also make the waiver unenforceable. These relationships include employer-employee and the public with those performing a public service. A last point, having a waiver does not bar anyone from filing a lawsuit against you. It merely provides a defense if someone were to sue you and may persuade the opposing party to either drop the claim or for the court to dismiss the claim. However, the process of being sued is costly and may prove disruptive to your business, even if the waiver holds up in court.
We've covered common pitfalls and enforceability. Now, let's talk about the actual writing process. How do you put pen to paper and draft a waiver that actually does its job? Tip number 1, ditch the legalese. There's a misconception that legal documents need to sound sophisticated and extremely formal. You do not need words such as heretofore or wherefore. In fact, using overly complicated legal jargon can actually backfire. If a judge decides that the average person couldn't possibly understand what they were signing, they might throw the entire waiver out. Write in clear, plain English to avoid this. Tip number 2, don't disguise the document. What is the title at the very top of your page? If it says sign-in sheet or registration form, you have a problem. The title needs to clearly announce exactly what the document is. Use titles like release of liability, waiver of liability, or assumption of risk. Make it big and put it right at the top so the customer knows exactly what they're signing. Tip number 3, use formatting to your advantage. As we discussed before, you don't want to bury your waiver in fine print. You want to draw the reader's eye to the most important parts. When you get to the sentence where the customer is agreeing not to sue you, make it bold and make it clear. Put it in all caps and underline it. Sometimes, businesses will make customers initial next to this specific section just to ensure that they read and reviewed it. Our final tip is to include what is known as a severability clause. While this may sound complicated, it is actually very simple, and it's a single sentence that you put at the end of your liability waiver near the end of the document. It essentially says that if a judge decides that one specific part of the waiver is invalid, the rest of the waiver still applies. Without this sentence, one bad paragraph could ruin your entire waiver. With it, the rest of the document will survive to protect you and protect your business. And that brings us to the end of our guide on liability waivers. We know that dealing with legal paperwork is probably not why you started your small business. It can feel intimidating, and it's definitely not the most glamorous part of being an entrepreneur. But getting this right is one of the most important things you can do for yourself. A solid liability waiver acts as a shield. It protects your business, and it gives you the peace of mind to focus on serving your customers. We've covered a lot of ground today, but if you only take a few things away from this video, let it be the following. Don't rely on a copy and paste template without reading it. Make sure your waiver specifically addresses the unique risks of your business. Make it incredibly easy for your customers to see and read your waiver, and always have a local attorney give a final review. Thank you for watching. If you found this presentation helpful, be sure to check out our other resources on establishing and growing your small business. We'll see you next time.